Welcome to tonight's event in defence of trial by jury, hosted by the Free Speech Union and Spiked. We have a fantastic panel for you tonight. We have the lawyer, former MP, and now Labour peer, Lord Boateng. We have barristers Kate O'Rahilly and Adam King, and His Honour, retired Judge Christopher Kinch. We're going to, each of the speakers is going to go to the podium and speak for 7 minutes, and I'll give slightly longer introductions just before they each get up to speak. And then at about 8 o'clock or so, we'll have a panel discussion, and then we'll throw it open to the floor at 20 past 8 or quarter past 8, and then have a Q&A for the last 45 minutes. And then do join us for drinks just through that doorway there afterwards. So let's start with Lord Boateng, who is a Labour peer who served as MP for Brent South from 1987 to 2005. He was appointed Chief Secretary to the Treasury in 2002 and also served as a Minister in the Home Office and the Department of Health. And from 2005 to 2009, he served as the UK High Commissioner to South Africa. And he began his career as a lawyer and a civil rights activist. Lord Boateng, over to you.
Thank you very much. Thank you. Thank you very much. It's good to be with you. We're here in this great hall, which is on a site that's been at the centre of legal practice for centuries. We're here because we believe, don't we, in freedom. We believe in freedom. Freedom and justice. Freedom and justice. And these two ideals represent the most precious of assets. And the values of freedom and justice in this world at this time are frankly being assailed and under assault, under attack everywhere. And we are here in this place to affirm them, to affirm the importance of freedom and justice and the place of the jury as central to the common law. The common law, England's great gift, I would argue, to jurisprudence and to the world. And I would argue, too, that it is certainly our greatest gift and our most enduring gift to the Commonwealth, where it has taken root and has survived a whole heap of stuff, political stuff, coups, revolutions in Commonwealth countries, as a standard around which freedom-loving people the world over, and in the Commonwealth in particular, are able to rally, whatever the vicissitudes and the challenges of the time and the politics of the circumstances in which they find themselves. I certainly found that in my own life, where my father, who trained and qualified at Gray's and who practiced law in the Gold Coast and then in Ghana, found himself at the centre of political events. And it was, at the end of the day, the common law that underpinned the struggle for freedom in that country. And it was the common law that ultimately prevailed over attacks on freedom from politicians and from armies. And there's a reason why that is the case. It's no accident that at the height of the Second World War, the then Prime Minister of the United Kingdom and the then President of the United States came together to sign the Atlantic Charter to provide a focus for global action against the tyranny of the Axis powers, it's no accident that the promise of the Atlantic Charter was self-determination, freedom, and justice. Those words weren't plucked out of thin air, freedom and justice. They meant something. And it's no accident either that many years later, Nelson Mandela, in his book, The Long March to Freedom, references specifically the Atlantic Charter, references specifically freedom and justice. No accident either that in the first independent sub-Saharan African state, the Independence Arch, whose unveiling I witnessed, has emblazoned on it the terms freedom and justice in what was the Gold Coast, in what became Ghana, the country where I spent the bulk of my childhood. And it's no accident either that all over the world today, as we speak, that very concept of self-determination, freedom, and justice is under attack by autocrats and by governments seeking to assert their power for whatever reason, with good or bad intentions, to find a reason, as they do so, to disregard or dismantle sources of opposition to state power. And they do so in the name of progress and efficiency. Progress and efficiency. 'Twas ever thus. Wherever liberty is curtailed, it's always because progress demands it, and always with the promise of greater efficiency and better outcomes. Greater efficiency and better outcomes. And when such arguments are deployed, we need to be on our guard. When such arguments are deployed, we need to examine them with great care. Not least because, as Lord Judge, who will be known to a number of you in this room, whom I recall appearing for at first instance as a barrister many years ago in Leeds, and with whom I later served in the House of Lords, it was Lord Judge who said so rightly that once juries are removed for reasons of convenience or efficiency, the process is irreversible. Once juries are removed for reasons of convenience or efficiency, the process is irreversible. Why is it important, then, to defend jury trials? Well, first, they're a crucial link, it seems to me, through participation between the communities from whom those juries are randomly selected and the administration of justice. They inspire public confidence in the justice system through that participation and give legitimacy to the outcome of the judicial process. And that legitimacy has never been more important than at this time, in which confidence in so many of our institutions is at an all-time low. And importantly, juries are a source of resistance to politicized law enforcement. At a time in which politicians of all stripes are all too often tempted to extend the reach of law enforcement into an ever larger range of areas in both the public and what was once thought to be the private realm. Juries retain the capacity to say, enough, enough, no further. And I've seen that myself at first hand in the course of my life and legal practice. Whether I was defending protesters against a poll tax, women at Greenham Common, Hunt supporters, and indeed Hunt saboteurs, in my practice as a barrister at the cab rank, I've defended both. Striking miners at Orgreave, Bristol youth at St Paul's. Largely black they were, but it was an all-white jury that said, no, this prosecution has overreached itself. There was no riot here in Bristol. And they acquitted them all. And they were criticized, not least by an eminent judge at the time who hadn't heard the trial, but who disagreed with the jury. But the jury were exercising the right to do what Sir William Blackstone said they had the right to do. He says, in his commentaries, the jury have an unquestionable right to determine the law as well as the fact. And it's this capacity that protects us all from over-criminalization, disproportionate punishment, and political pressure on the prosecuting authorities. And the origins of jury trial in the Middle Ages were as a means by which local communities were empowered to evidence local conditions. They were about evidence. They weren't, in fact, originally juries in the Middle Ages about decisions as to fact. And they were impaneled, those jurors, from the boroughs in which alleged crimes were committed to do just that, to evidence local conditions. And they evolved over time to become judges as to fact. And they faced pressure and coercion historically to arrive at decisions which were acceptable to the ruling powers of the day and the beliefs to which they adhered. In Bushel's case, known to many of you, in 1670, jurors acquitted William Penn, despite judicial pressure. The judge didn't like it and fined and imprisoned the jurors. And the Chief Justice at the time ultimately ruled that a juror cannot be punished for delivering his verdict. And this established jury independence in the face of state coercion. The state, many years later, centuries later, in different circumstances, hit back, as it is prone to do, by seeking to rig jury selection with John Wilkes, when John Wilkes MP championed freedom of the press and protection against arbitrary arrest, with the cry, "Wilkes and liberty," and argued, Wilkes did with John Bull, for the random selection of juries as a safeguard against state repression. A randomness that is still questioned by some to this day. Indeed, Toby, I think you were there when we had a question and answer session in the House on juries. It was suggested by one of our noble colleagues on the cross benches that taking people off the street randomly, as he put it, was an odd way of ensuring justice. And yet we know, as I pointed out to him, that it is precisely the act of bringing together randomly a number of ordinary people, yes, taking them off the electoral register, off the street. It's exactly their randomness. It's exactly bringing them together to hear a case that is a safeguard against bias and prejudice, any bias and prejudice that may lurk in the judicial mind. It's a counterbalance against state overreach through state-appointed arbiters of fact and law. And given a choice, to whom would you rather entrust your liberty or reputation? A judge or a jury?
Jury.
And that is the answer that the overwhelming majority of people will give. Because we know that juries act as a filter for prejudice. We know that they are the best way of deterring or exposing unintended bias, that group deliberation works in that way to counter coercion of any sort. Juries are a success story. So why now curtail jury trial for reasons of progress and efficiency? To reduce delays whose origins have never been shown to be with juries. They've never proved the case. Indeed, they've never marshaled any evidence to demonstrate that it is juries that cause delay. What we know is, and what almost every legal practitioner will tell you, that delays are more likely to be the result of a decade or more of underinvestment. A decade or more of underinvestment under all parties, closed courts, and a shortage of practitioners. The curtailment of resources for our justice system. But surely we are not as a nation so poor. We are not as a nation so poor or so poorly managed that we can no longer afford juries. Surely we have not sunk to that level. Trial by jury, Lord Devlin said, and it's as true today as it was in 1956. Trial by jury is the lamp that shows that freedom lives. Trial by jury is the lamp that shows that freedom lives. We don't have a written constitution. No, we don't. But the jury, as we have come to know it, is embedded in both common law and statute. It represents the very best of this country and this country's tradition of adherence to the concepts of freedom and justice and the values that underpin. Thomas Jefferson viewed the jury as superior even to written constitutions. And he said this: "I consider trial by jury as the only anchor ever yet imagined by man by which government can be held to the principles of its constitution." So to those who argue that these islands of ours have no constitution, and therefore that the people have no right to jury trial, who would argue that the people have no right to jury trial, to those people, I say, we say, don't we, that we have the common law. We have centuries of practice in that law, and in that law, juries have evolved over time as central to our system of justice. And no government has any right to tamper with that. No government has any right to tamper with that without the express mandate from the people. Without the express mandate from the people. A mandate delivered at the ballot box. And you know, the reality is that no political party has sought such a mandate. No political party has ever told the electors, we are going to curtail jury trial. No party has any such mandate. And no parliament should enact any legislation that curtails access to and the exercise of jury power. Because jury power is people power. Jury power is people power. And power belongs to the people, not to judges or to politicians. Juries that connect the people to our system of justice are surely the best and surest guarantee of all our freedoms, of all our freedoms. Why are we here? We are here to preserve just that, to preserve freedom and justice. There is nothing more important or of greater value than that. Freedom, justice. That's why we're here. For juries and liberty, and so that the lamp is never dimmed. Thank you.
Thank you very much. Thank you, Lord Boateng. Next up. Next up, we have Kate O'Rahilly, and her practice encompasses criminal trials and appeals, extradition and public law in the field of criminal justice. And she's acted in many of the country's leading criminal appeals in recent years, including the seminal appeals in the Post Office miscarriage of justice scandal. She also has particular expertise in terrorism and national security work and the application of international human rights law in the field of criminal justice. Kate O'Rahilly.
Thank you. Good evening. Thank you very much for having me, and thank you for the words we've just heard. They were wonderful. I've been asked to speak to you this evening about the common sense understanding of justice which jurors bring to a criminal trial. I've chosen to interpret that as meaning, what role does the jury's common sense play in a criminal trial? What is the value of having 12 independent people bringing their common sense and their life experience when they sit in judgment on their fellow citizens? And my answer, and I'm sorry to repeat some of what you've just heard expressed so eloquently, is that the jury's common sense, their life experience is the best weapon against weak prosecution decision-making. Their common sense is something which can, and often does, as you've just heard, level state overreach. And despite our constant worries about how juries are easily prejudiced, and there are genuine concerns about that in criminal trials all of the time, in the vast majority of cases, juries are actually the best safeguard against the prejudice that can come to bear on a defendant in a criminal trial. And everyone involved in jury trials will know that there will come a time, usually pretty early on, when the judge will turn to the jury and say, ladies and gentlemen, you're here to bring your common sense to these proceedings. And it's nearly always the case that prosecution and defence counsel's closing speeches will appeal to the jury's common sense in the same way. And it's important not to be flippant about this, because appealing to the jury's common sense is not some sort of cute little homily. The jury's common sense is one of the most powerful tools in the courtroom. It's quite common for juries to send notes asking more intelligent and sensible questions than the advocates have. They often spot things we have missed. I'm guilty of that. And this sort of thing happens so often because, unlike us, the jury is witnessing the evidence from a completely independent perspective, and they are in the best position to see the wood for the trees. And without those 12 members of the public assessing whether the state has discharged that heavy burden, without them there would be no democratic participation in criminal trials. And so trials would be devoid of the common sense, realism, and emotional intelligence which people deserve when they are being prosecuted by the state. These qualities, common sense, emotional intelligence, and realism, these are qualities which are often sorely lacking in the decision-making of the Crown Prosecution Service, which is the most important lever in our criminal justice system. And I'm afraid the thing is that the British state quite likes prosecuting people. Since 1997, I looked this up today, successive governments have created literally thousands of new criminal offences, and by 2010 there were apparently nearly 4,500 new criminal offences on the statute books. And in more recent years there have been, some of you may know, controversially, more widely drawn criminal offences, new offences relating to protest, online communications, and public nuisance. And in that final example of public nuisance, we now have expanded that offence to criminalising acts which cause serious annoyance. And the end game of all of this is that there now seems to be a crime for just about every facet of human behaviour. And unfortunately, the CPS seems only too happy to try and enforce these statutes with very little discretion or common sense. And so we find ourselves, unfortunately, with Crown Courts being packed to the rafters with thousands of ordinary crimes, allegations so ordinary and banal that they are plainly not in the public interest. And the best example of this problem is the never-ending tirade of prosecutions for assaulting emergency workers, closely followed by a similar stream of prosecutions of peaceful protesters, and the list goes on. An example that I can give you in relation to my own practice, this week I was instructed in a case in which a man of good character is being prosecuted for assaulting a police officer. And the particulars of the allegation are that he, and I kid you not, and I quote, squeezed the police officer's bicep. That case and the officer's bicep, they're currently on their way to Kingston Crown Court for trial. One assumes at some point in 2027 or 2028, by which time I sincerely hope the poor officer has recovered. And so the reality is that in a system which is so replete with prosecutions which lack all common sense, democratic participation by a jury who will bring common sense, who can see through prosecutorial overreach has never been more important. David Lammy's answer to the backlog, of course, is to rid our system of common sense rather than apply common sense elsewhere, such as, for example, by encouraging the CPS to cut the pipeline of trivial allegations, or by considering amnesty or diversion for cases below a certain threshold of seriousness and which have been in the backlog for a defined period of time. These are things which should be given serious consideration. Instead, he has the audacity to suggest that a person of good character, for example, who wants 12 fellow citizens to apply common sense to their case, is gaming the system, not a person who needs a jury to scrutinise the frequently ridiculous decision-making of the Crown Prosecution Service. But it's not just trivial allegations which so desperately need juries to deliver justice for defendants, because the way in which more serious cases are now prosecuted is also relevant to the role that a jury's common sense will play in a criminal trial. And I just want to say something brief about terrorism cases. The Leveson report says very little about the position of terrorism cases in the context of the proposals to restrict jury trial, but my personal concern is that given the way this government is going, my real concern is that juries at some point could be removed from terrorism cases based on the fiction that they are too complex or some other fiction they come up with. And whether they have a jury or not may eventually become subject to the court's discretion. And the reason why terrorism cases are really important in the context of these potential reforms is because a terrorism trial forces a defendant to confront some of the worst prejudice that a defendant can ever face in criminal proceedings. But in my experience, the main thing which is capable of mitigating that prejudice is the jury. I didn't always feel like this, but I do now. Not least because the majority of terrorism cases now prosecuted by the CPS are not cases about attacks or violence or plans to do the same. The CPS's willingness to bring proscription-related prosecutions means that the banner of terrorism now includes all sorts of cases which perhaps 10, 15 years ago, would have been really hard to envisage. And I suspect these cases are often surprising to juries when they come across them. Other than prescription-related cases, the majority of terrorism prosecutions are for offences which pertain to social media use, possession of things like the anarchist cookbook, vague allegations of membership of organisations, and increasingly the attendance at certain types of protests. And so the typical terrorism case now is one which frequently centres on the prosecution or scrutiny of a defendant's mind or mindset, often the mindset of young men, even more often young men who are marginalised in one way or another. And this area of practice now has much more to do with prosecuting ideology rather than hard facts. It is increasingly nebulous. So as long as we're trying to regulate ideology through extensive criminal prosecution, we need juries. We need their common sense scrutinising prosecutions, and we need it desperately. That is my short defence of jury trial. But a good defence, if it be a good defence, is not enough. Our arguments need an audience. We need the public to understand what David Lammy wants to take away from them. And it's fantastic that events like this are taking place so we can promote the public's understanding of the jury system, which is so precious. Thank you for listening.
Thank you very much, Kate. So next up, His Honour Christopher Kinch, who was a senior circuit judge and resident judge at Woolwich Crown Court for 11 years, from 2013 until his retirement in September 2024. Before appointment as a judge, he spent 13 years as a QC, prosecuting and defending in cases in London and across England and Wales. His time in Silk included stints as head of chambers at 23 Essex Court and as chairman of the Criminal Bar Association.
Thank you very much. Thank you very much, Toby. I believe I'm here to give a nuts and bolts
view, drawn from my experience as a barrister and 12 years as a judge, and bearing in mind that judges aren't actually by convention allowed to speak about policy. The advantage I have is being fairly recently retired. I hope I still have a little bit of shelf life left to give you a view from the coalface, as it were, that may be of some value. Can I start with three propositions that I hope are actually fairly uncontroversial? We have in this country two methods of providing a fair trial. You can have a summary trial for minor offences, usually, in front of a set of magistrates, lay justices, or a district judge. But trial by jury is undoubtedly the gold standard. It is, and it may be, as Lord Boateng's commented, an odd system in its origins, but it's the best system yet devised for deciding whether guilt has been proved by the state against an individual. And you need look no further than the present Secretary of State's for Justice's view. Even Mr. Lammy wants to retain jury trial for the most serious offences, at least for now. Second proposition, juries provide a means for community participation at the very heart of the criminal justice system. No other pillar of society permits that. You don't get the armed forces asking lay people what they should do about this or that threat. You don't get Parliament very often asking the public what they should do. Once every 5 years or so, a tick in the box, and that's about it. That provides a mandate to do, it seems, whatever you want. But criminal justice system, with all its faults, allows juries in, and we say to them, you take ownership of this case now, you decide the crucial question in the case. It's not for the judge, too important for him or her, and the judge is not allowed to dictate the decision. And that has one huge benefit for judges. We are shielded from responsibility for that decision. And that's not a minor consideration from where I used to sit when you see headlines, enemies of the people, softy judges, and that kind of thing. So the fact that the community are involved and make those key decisions is a really strong feature of jury trial. That leads me to my third non-controversial proposition, which is this. If you are intending to limit jury trials in any significant way, you require a powerful justification. We haven't heard yet anything that amounts to such a justification from the government. The Courts Minister tried, Sarah Sackman. People are gaming the system. We've got to put a stop to it. The Minister, with great respect, I should say, doesn't know the difference between a symptom and a cause. To the extent that anyone is gaming the system by putting off the day of reckoning, that course is only attractive because of the backlog that's been caused by years of government underfunding. Secretary of State David Lammy, victims are having to wait years for their cases to be heard while the courts are occupied with trivial cases. What nonsense. The courts are not overrun by cases of thefts of bottles of whiskey or thefts of bicycles, which for some reason was one that Mr. Lammy alighted on. If they were, quite simple for the resident judge, and I would have done exactly this. We're not trying that this year when there's a sexual assault case waiting in the wings. Get that case on. Hoy the theft of the bottle of whiskey off for a year or two. That's not going to bother anybody. So what about Sir Brian Leveson, a very, very distinguished figure in the criminal justice system over many years? But he accepted terms of reference for his inquiry that boldly stated that the criminal courts, even properly funded, could not cope with the current workload. I tried to ask Sir Brian in a written submission, how do they know? Where's the evidence for that? It's not as if anyone's ever tried properly funding the Crown Courts. The unspoken reason I would suggest for all these cuts in jury trials, juries are expensive. You have a bureaucracy to organise them, to summon them, to get them there. They pay them pitifully low expenses, but over all of it, they're an expense. And the Ministry of Justice likes nothing better than making cuts to please the Treasury. Now, I don't have the distinction of some of those people who've been pontificating about jury trials and saying they need to be cut. But let me tell you this, my bread and butter for the last 12 years of my career was running a court, prioritising cases, managing lists, and I hope I know a thing or two about them. But it doesn't appear that anyone's actually troubled to ask those of my colleagues who are still at the coalface what they think about it. So let me turn to slightly more controversial topics. Are the Lammy reforms going to do anything to reduce the backlog? Well, this is something of an emergency, isn't it? 80,000 cases rising to 100,000 if nothing happens in the next 2 years. Mr. Lammy says, well, nothing will happen for 2 years, but we hope things will be coming down by then. And maybe we'll get to manageable levels by 2035. Well, that's an ambitious programme, isn't it? In the meantime, I would submit that judge-alone trials are unlikely to make much of a significant saving in time. The fact is that a lot of us Crown Court judges are just not as quick as Sir Brian Leveson in sorting out reasons and how to decide a case. That's why he was president of the Queen's Bench Division and we were Crown Court judges. We just had to work a little harder at it. Reasons, giving written reasons for decisions will take time. They have to be sufficient to inform members of the public why a judge has decided a case, and also they have to be robust enough to stand up to the Court of Appeal. It's not just me. The Institute for Government, on my reading list for tomorrow, recently published research that suggests there'll be very limited effect on the backlog. The other point about the reforms is that if they'd asked, the backlog can be reduced by courts that are sufficiently resourced, and this is what you should do. Firstly, treat this as an emergency, please. Suspend the cap on sitting days. Don't go on about how you've given 1,000 more sitting days than the last government. Just suspend the cap. Push for judges around the country to sit as many cases in as many courts as they can over the next 2 years. We managed to get the criminal justice system going after COVID, for goodness sake. Nobody told us how to do that. Crown Court judges and their staff and the advocates who support them just got on with it. And for goodness sake, we will, I'm sure, I say we, my colleagues who are still there will be able to achieve things. In early 23, Woolwich managed to cut, that's my old court, to cut its backlog by nearly 20% in about 6 months. We did that by an intense system of case management, really scrutinising, triaging cases. But then we lost 2 judges, we lost some members of staff, and we just couldn't sustain that level of effort. Around the country, there are other initiatives, some flourishing, some not. Liverpool and other courts don't actually have a huge backlog. Get in touch with those courts. Get them, stick the resident judges around the country in a conference room for a couple of days. Give them a little bit of beer and wine, and they'll come up with the solutions you want. In the longer term, I hope, Toby, I've just got two points. In the longer term, what should be done? That's my prescription for the emergency. In the longer term, this is where it may get a little bit more controversial with this audience, I don't know. But Parliament needs to do its job, and do its job properly. Parliament has to decide where to draw the line between summary offences and those which can or should be tried in the Crown Court. Don't leave it to some judge as to whether this case might or might not get 3 years or more. I mean, that's just a silly and absurd idea. And you'll understand that when you have a new statute that comes in and creates a new offence, Parliament has to decide, well, is this going to be one that's just a summary offence, or is it going to have a right to trial, or indeed is it going to be indictable and you can only try it in the Crown Court? Sometimes, in the light of experience, that decision needs to be reconsidered. And I would have to concede the sky didn't fall in when in the 1970s Parliament decided that the offence of driving with excess alcohol should no longer have a right to jury trial. And then in the 1980s, when driving while disqualified lost its right to jury trial. The sky didn't fall in, life went on, and those were, I would suggest, legitimate and responsible actions by Parliament, but they were considered actions. And it's much more difficult, I would suggest, to justify cutting cases that have featured trial by jury as an option for decades or centuries. You can muck around with an excess alcohol offence that is only a few years old. I will put that in the wrong category, but be very careful when you're dealing with assaults, thefts, and matters of that sort. I want to finish with just one example. I'm going to pick up, if I may, on a case that Kate mentioned, because Parliament could make a start with looking at the raft of offences that have been pushed towards the Crown Court in the last 30 years for policy reasons. Assaults on emergency workers, an offence introduced to cover the unpleasant cases where someone had used violence towards paramedics, hospital staff, firefighters, and so on. Didn't happen very often, but when it did, it was very, very unpleasant, and Parliament, no doubt, right to intervene. But any significant attack on anybody like that could be charged as an assault occasioning actual bodily harm, with a maximum sentence of 5 years. If it didn't result in any lasting injury, there was no specific offence to cover the behaviour other than common assault. So that was the problem, and it was a supportable policy to bring in a new offence. However, to demonstrate how tough they were being, Parliament decided to give the offence a 2-year maximum sentence and make it triable either way. They also decided to categorise all police officers as emergency workers, when there was already a perfectly satisfactory existing offence of assault on a police constable in the execution of his duty, which was triable swiftly in the magistrates' court, punishable by 6 months. What happened was Crown Courts up and down the country saw an explosion in the number of these minor assaults. Over 90% of them featured assaults, minor assaults on the police. I hadn't heard of Kate's one, but certainly elbows, and a headbutt to a police officer's knee was one of the more egregious ones that came across my desk. No, I kid you not, the man was on his knees, and as he stood, he hit the police officer's knee. And these are seriously coming in front of the Crown Court, and they shouldn't be there. Dip samples at some courts that I took part in suggested those amounted to 10% of the incoming cases in my last year. Cut all those out, make an immediate impact on the backlog, and then have a careful, sensible, educated trawl through either way offences and decide if there are more that could legitimately revert to summary-only offences. Otherwise, make sure the Crown Courts can get on with their job. Thank you very much.
Thank you. So our last speaker is Adam King, a criminal barrister at QEB Hollis Whiteman, where he has focused his practice on serious and complex jury trials. He's an enthusiastic proponent of free speech and particularly enjoys defending such cases, including some for the Free Speech Union. He also occasionally writes for Unheard on legal topics. Adam King.
The negative reaction to Lammy's proposals, perhaps I should call them Leveson's proposals, since it was he who set the hair running last summer, has reassuringly come from both sides, all sides of the political landscape. That's a wonderful thing. And indeed, one might take that fact, the fact that Rupert Lowe and Shami Chakrabarti can stand shoulder to shoulder in opposition to this as some indication of what a terrible idea it is. But one of the points I made in a piece I wrote for the Telegraph last year was about tradition, which of course is traditionally more of a right-wing talking point. But I think it's one that we shouldn't shy away from here, because it's important. By the way, I think fighting Lammy on his own terms, on his own ground, is probably the way forward here. And there's innumerable quotes that he has uttered that can be shoved in his face over and over again. That's probably the best place to start. But there is a very important argument from tradition here. Tradition has been a dirty word for a long time now, at the very least since Tony Blair came to power 30 years ago. To invoke tradition as an argument for something is usually to concede defeat. To the progressive mind, traditional things are bad things and they need to be got rid of. Often all it takes to get rid of something is to call it outdated or anachronistic, and victory is yours. Of course, sometimes traditional things are indeed bad. It's been around for a very long time, invites the perfectly proper response, so is syphilis, or whatever. But sometimes the mere fact of long use is the reason why something works. And this applies to juries. Because justice, famously, doesn't just mean justice being done, it's justice must be seen to be done. And part of it being seen to be done, or related to it, is justice being felt to be done. And the fact that we in this country, and one or two others, have been doing things in this way for so long, means that people here believe in it. And if you believe in a certain way of doing something, of achieving justice, you are more likely to feel that justice has been done. So in fact, the argument for juries doesn't entirely depend on juries being the best way to get the most accurate verdicts. I think it is, for many of the excellent reasons that Lord Boateng and others have put forward. But it's hard to get evidence on that, actually. You can't, perform experiments. There's not data on it, really. It just has to be sort of anecdotal from people like us, which is worth something, but it's not going to settle it with all opponents. But if people believe in a verdict, if they think it has been achieved in a good way, then a large part of justice has, in fact, been done. So opponents of jury trial, I've met very few, might say, well, you say that jury trial is the lamp that shows that freedom prevails, or whatever the Devlin quote was. Fine, but most of Europe don't have it. You go on holiday to the Netherlands, you're not terrified that you're going to be tried by a judge alone. And the Dutch don't seem bothered by it. They've never had juries. Part I discovered when looking that up for about 5 years when Napoleon was in charge in the early 19th century. But they have basically never had juries, and they were very keen to get rid of it as soon as they got rid of Napoleon. So there has to be an answer to that, right? We don't think that the Dutch are living in terrible peril. But the point is, they don't believe in jury trial, so they don't need it. They've never had it, whereas we have. Now, there might be something in our national psyche, and I would be prepared to believe this, that there's a sort of respect for the man on the Clapham omnibus, the bloke in the street or woman, and a distrust of experts. Maybe there is something in our national character along those lines. Maybe there isn't, but for whatever reason, we believe in juries. And without juries, people won't think justice has been done. They'll say, who's that pompous old fool telling me I'm guilty? I'm not having that. An Englishman has been able to be tried by juries for 800 years, he'll say. And he'll be right. So that actually is the reason why tradition really matters. Lord Sumption, a man I have untold respect for, believes in reasons. And he thinks, and he's written about this, he thinks that the fact that juries don't give reasons means that their verdicts cannot be properly challenged. He would like to see the back of juries altogether. But being a fan of freedom and democracy, he sensibly acknowledges that although that's his view, he knows that it's not everyone else's view. And so he respects the majority desire for juries. And perhaps, relatedly, although he hasn't, to my knowledge, talked about my specific point on this, but perhaps he would acknowledge that it is because people believe in juries that we should keep them. Relatedly, with a system that has been in place a long time, we often don't know why it works. Chesterton's fence, which you're probably familiar with, fairly well-known concept, goes some of the way towards explaining that idea, illustrating it. If you come across a fence across a road, hypothetically, don't pull it up too hastily. Think about why it might have been put there in the first place. But I think the fundamental concept goes a bit further even than that. And it's set out very convincingly in a book by Joseph Henrik called The Secret of Our Success, about cultural evolution. And to put it very briefly, because of the way culture, in the broader sense, develops, that is, by accumulating ideas incrementally from one another, from successful people doing things in a particular way, we often end up with something that works, but we don't know why it works. And two of the brilliant examples Henrik gives in this book are Inuits back in the day hunting seals under the ice, which, as you can imagine, is the most unbelievably complicated and difficult process that no single Inuit or even a team of very clever Inuits could work out for themselves. Rather, it's accumulated knowledge copying each other over a long time, and they end up with this amazing system that works. But they don't know why all of it works. Another example is the preparation of manioc by Amazon tribes, which again requires an unbelievably long-winded, laborious process to avoid two different types of poisoning. And the people who spend their time doing this have no idea why they need to do it. They just know that if they don't, they get ill. They don't know what each individual bit achieves or anything like that. But following tradition will literally save your life in those circumstances. I'm going to do it the way my mother did it, because if I don't, I'm worried that I might die. And Henrik, in fact, gives brilliant examples where there are some cases where some of the steps in the long, elaborate process are in fact completely pointless, but no one wants to change them because they don't know which those steps are. And so it could be that the jury system is a little bit like that. His Honour Judge Kinch spoke of the participation as a juror that actually might mean rather more to national cohesion than we would give it credit for, right? There's no other area where you participate in that way. And even those people who never participate as a juror have the notion that they might, and they feel a certain togetherness with their fellow man for that reason. So things like that, perhaps. I see time's running on, and I know we need time for questions and things, so I'll just very briefly mention jury equity and perverse acquittals. Again, no judge, well, not no judge, but most judges are not going to hold that up as the great thing about juries. You know, the reason juries are brilliant is because they can ignore the law and do what they want. It's a bit of a dirty secret, if you like. But that could, in fact, be a very important part of the system. Perverse acquittals are rare, they're unsavoury when they occur, not necessarily to the winning side, but no one really likes it. It feels like a flaw in the system. But the fact that it is possible means that when a verdict comes, particularly an acquittal, everyone just sort of has to lump it and respect the fact that it's come. The fact that juries can technically ignore their legal directions means it's very difficult to complain about a conviction on the basis that some emanation of the state, some pompous old man who's in the pocket of whoever has done this to me. In fact, the jury have chosen this, and they could have chosen otherwise, and they didn't, so I've got to live with it. That could be one of those unknown little bits of the jury system that makes all the difference. There we are. Thank you very much.
I think we're going to go straight to the Q&A. Can we have the first question? Is there anyone in the audience who wants to defend David Lammy / Brian Levison's proposals? Anyone who thinks juries are overrated? Okay, Louis, down the front, very bravely volunteering, an FSU employee.
One point is, of course, we've discussed criminal trials, but we know that in America and historically in England, that we had trials for jury in defamation cases, and in America for all sorts of chaotic civil cases. Is it a problem that defamation trials in England are no longer tried by jury? And are judges making worse decisions than they once did? I mean, perhaps we don't have George Carman making his eloquent speeches, but perhaps the decisions are as good as they once were.
Okay. Let's now go to a question. Who has a question for one of our panelists? Gentleman with his arm up over there, Jan, about midway down.
I just wondered whether occasionally juries act against the interests of defendants. For example, Lord Sumption has pointed out that sometimes juries feel a need to, in serious cases, to act to convict. In the case of the Northern Ireland terrorist serious offences, the Diplock courts have had no appeals against them, whereas Irish terrorists were found by English juries to be guilty when they were in fact not guilty.
Okay. Do you want to respond to that, Lord Boateng? Or Kate, did you want to respond to that as a terrorist experience? Yes. Sorry.
I'm not a terrorist, by the way, but the Diplock courts were brought about against a very particular geopolitical background. And we all know, I think, or many of us know what the complaints... Yeah, sure. Just that the Diplock courts were brought about against a particular background. They were a response to the difficulties that were being faced by defendants who were facing jury trial in the 70s and 80s and so forth. The Diplock courts have been invoked as a sort of comparison at various points during the discussion of these reforms. I think it's a false comparison. I think it's a bad comparison. These proposals have nothing to do with the geopolitical context that relates to jury tampering and so forth. But yes, juries often do act against the interests of defendants, or we as advocates perceive them to act against the interests of defendants. The most straightforward example is in cases where you feel that there has been overwhelming prejudice. Overwhelming prejudice most usually happens in terrorism cases or sex cases. In terrorism cases, it typically comes from uncontrolled publicity. The contempt of court regime is pretty supine, in my view, and that plays a huge part in how prejudice comes to be uncontrolled when you're talking about a jury trial. So yes, juries do act against the interests of defendants all of the time. Judges are equally capable of doing so. And the fact that it happens, or that there are certain contexts in which trials occur which make it very difficult, is not good enough to justify restricting the system in the way in which these proposals argue for. But yes, there will always be difficulties. It's not the perfect standard. Jury trial is not the perfect system. It's simply the best system we have for dealing with certainly ordinary crimes. So that's what I would say. I hope that's in some way helpful.
I think I would also add that Lord Diplock, and I mean, I'm old enough to have been around and indeed practicing at that time. Lord Diplock himself made it very clear, and it was made clear at the time, that the Diplock courts were a constitutional aberration. I mean, that's how it was put, that they were designed to deal with a very specific set of circumstances as they existed in Northern Ireland at the time. And they were seen at the time as being time limited and not in any way as a model for the future conduct of such cases going forward. But yes, I mean, there are miscarriages of justice occur, undoubtedly. But in my experience, particularly in relation to the terrorist offences of the 70s and 80s, the miscarriages that occur were not as a result of jury prejudice, they were as a result of prosecution failures, and some of those failures were not accidental. They were quite deliberate. People were stitched up. That was the source of the injustice. So I don't think you can blame juries for that. So juries are not perfect, but they are, in my experience and view, the best and surest defense against injustice.
Another question. I think the gentleman towards... Actually, let's have one on this side. There's a gentleman near the front with spectacles on, just here, Vinay.
Thank you. Really a question for anybody on the panel. I wonder if justice is always served these days by the sheer length of some criminal trials. And one has the impression that a couple of hundred years ago, maybe, you could almost be arrested on a Monday, tried on a Tuesday, have your appeal heard on Wednesday, and be hanged on Thursday. Now, I'm not suggesting that we should go back to that, but in contrast, the Lucy Letby trial lasted a year. And I have to ask myself, what on earth did the jury do when they got into the jury room? I can't remember what I was told yesterday afternoon, let alone what somebody might have said to me 12 months ago. So my question to the panel is justice being served by juries being forced to sit and listen to months and months of evidence?
Christopher, do you want to take that one?
Yes, I wouldn't try and pretend it's desirable to have a trial lasting a year, but I'm trying to think of the longest one. I've certainly presided over trials that have lasted several months, and I've also been an advocate in trials of 3 to 6 months. One of the features of those trials, almost universally, is the attention that the jury display. Once you have got a jury who are prepared to sit for that length of time, they really take ownership of the trial. Some trials just do take too long. It's a flaw in the system. But interesting, there was a paper produced by the Southwark judges, and Crown Court at Southwark is, as you'll know, a centre for major fraud trials in this country. Vanishingly few cases there actually last anything like a year. Vast majority completed within 3 months. Still a very long time, and it's quite an imposition on a jury, but it's just about manageable. Judges also have to accommodate, when you have a long trial, you have to accommodate that people go on holiday. They have commitments, all sorts of commitments during a trial. And that's very often one reason. So they'll have little breaks while during the trial. They come back, in my experience, refreshed and invigorated. And they get through them. So not a desirable feature, but it's part of the price you pay for having that system.
I would just add that I think some of the long fraud trials that take 3 months could, if the prosecution put the case differently, be done in 3 weeks without much loss of gravity. And that would free up an awful lot of time.
Okay, another question. There's a lady just towards the... Is it just Baroness Fox, I believe?
Thank you very much. Excellent panel, by the way. I wanted to know whether you thought, despite the excuse given of efficiency, whether there wasn't a prejudice being exhibited by the way that this is being pursued, in as much as a turn against the general public and their common sense. And I've been worried for some time in discussions about, for example, sexual violence and rape against women, that juries can't be trusted, that they might be misogynistic, or they might need to go on special training courses, or that too many of the cases are too complicated for the public. And it seems to me to be quite an affront. Whereas actually, when you talk to anyone who's been on jury service, it's amazing how seriously they've taken it, and really sort of risen to the occasion. But anyway, is there a political aspect to this attack on jury trials beyond ineptitude and not thinking through the efficiency argument, which obviously won't work anyway?
I'm going to ask Lord Boateng to respond to that in 1 second, but just to echo your observation, when I asked a question of a Justice Minister in the House of Lords about David Lammy's proposals, part of the defence she made for more trials being heard by magistrates and district judges as opposed to juries is that magistrates and judges have the advantage of being diversity trained, whereas juries don't. They're merely diverse. Anyway, Lord Boateng.
I do think, and I don't think it's limited to any one party, because I think we find it on the cross benches too. I mean, we've heard it at the question session we were all three of us were at in the Lords. There is a sense that there is a group of people who somehow know better than the rest of us. I do think that's there, and I think it's a feature of this debate. And I think we have to call it out. And it's worrying because I do think there is a tendency to believe that elites somehow possess virtues that ought to be applied and that they can somehow be trusted more. And my experience is that actually ordinary people selected randomly in juries, take the issue very seriously, see through the crap, and there's a lot of it about, and come to verdicts that represent common sense and justice. That's my experience. And I really do take issue with this notion that somehow juries are more likely to be prejudiced or bigoted in relation to race, gender, or religion. I just don't think that's borne out by experience. Let me give you this example that's got absolutely nothing whatsoever to do with jury trials. But for a long time in this country, it was I've been around a bit, and I can remember this time, and looking around, there's a number of you who can remember it as well, too. But there was a time when there were no MPs of colour in Parliament. And there was a time when there were very few women in Parliament. And various reasons were given for that. One of the reasons was, well, we would like to have selected them, but really, the voters won't stand for it. They really don't want a woman. They don't want a person of colour. And if we put up a woman or we put up someone of colour, well, they'd never get elected. Well, guess what? Guess what? When women and people of colour organised, as we had to do, to make sure that we did get selected, the people came out in droves to vote. And there was no evidence whatsoever that ordinary people were biased on the basis of race or gender. So I really do take issue with that being used as some sort of cover for something that is basically elitist and illiberal.
There's a woman towards the front here, Jan. An ordinary woman with her hand up.
Hi, an ordinary woman from Snowdonia. I've come all the way from Wales because this is such an important subject. So a couple of hundred maybe people here tonight, how many of you have been in a jury? Wow, look at that. Because I'm 63 and I've just had my first ever summons to serve. And I'm quite excited, actually, a little bit nervous. And I do feel honoured to be part of such an important thing. So maybe I'll pick your brains afterwards, how to be a good juror. So I think it's something that we have to defend, because it's one of the cornerstones of an intelligent democracy.
Thank you. We've got a question from David Rose, Vinay, about midway down, newly appointed research director of the Free Speech Union.
Hi, I recently joined the Free Speech Union after a long career as an investigative journalist in which I covered many miscarriages of justice. I was present on the extraordinary occasion in 1989 when the Court of Appeal released the Guildford Four. And I absolutely endorse what Lord Boateng has said about the way in which innocent defendants were stitched up by prosecutions. This was not the fault of juries, it was the fault of prosecutions, and a degree, frankly, of what can only be described as collusion between the prosecution and the judiciary in the way that those cases, and some of those that Lord Boateng was involved with, and I covered as a reporter. My question is this. By definition, the reasons by which a jury reaches its verdict are, of course, secret, they're private, we never know. And since that historic day in 1989, when the Guildford Four were freed, I've seen two things happen. First, a tremendous sort of wave of liberalism sweep through the Court of Appeal, and a much greater willingness to overturn jury verdicts as the penny dropped that so many cases had been fought on a dishonest and unreliable basis. And then, starting perhaps in the mid-1990s, after the Royal Commission on Criminal Justice and the establishment of the Criminal Cases Review Commission, an intense reaction in which the Court of Appeal has become ever more reluctant to disturb jury verdicts. So my question is this. In these cases where now judges will have to give reasons for those guilty verdicts, will that make the Court of Appeal more or less likely to be willing to disturb those verdicts? Or, alternatively, will that sort of collusion that I witnessed years ago between ill-conceived and dishonest prosecutors and judges mean that, in fact, the system will close ranks and make it almost impossible for those verdicts to be reversed?
Kate, do you want to take that one?
I think more than one of us will come in on this, but I think inevitably, and particularly in a complex case, a serious case, a controversial case, the duty to give reasons, if you're sitting as a judge alone, will impose an incredible burden on that judge, because they're going to have to give such detailed, bomb-proof reasons to be able to withstand the scrutiny of the Court of Appeal. one thing that may happen in such a system is that the Court of Appeal's focus, and this is not a very well thought through reaction, but it's my reaction to your question, that the Court of Appeal will inevitably focus on the quality of the reasons rather than the quality of the evidence which has underpinned those reasons, in a similar way to what happens in public law, the standard of rationality in judicial review. And it'll become a much more formulaic analysis. Well, are the reasons good enough? Rather than scrutinising the safety of the conviction, which is a test that we all whinge about at the moment in relation to the Court of Appeal. But the safety test, by reference to simply a jury's verdict, in my view, is better and has proved to be better over the years, particularly with things like the development of the CCRC and so forth. That's my immediate reaction to your question, and I suspect others will have something else to say.
Did you want to comment on that one, Christopher?
If I may, I think it's very difficult to predict, because what we're going to see if this goes through is a whole new area of jurisprudence where the Court of Appeal Criminal Division, and I was privileged enough to sit there part-time during my years as a resident judge, and certainly the starting point tends to be this is a jury's verdict, and it's going to take quite a bit of persuasion to for us to say this is unsafe. But when you're then moving to looking at a judge's reasons, what are the rules going to be? Is the judge going to end up giving, as Kate suggested, and I certainly would want to, detailed reasons that explain why they've believed a particular witness, why they've drawn this or that conclusion? Or is it going to be a much more cursory thing, rather resembling the jury's route to verdict, which, by the way, in the present system, does provide an insight into a juror's reasoning if you assume that they follow the directions in law that they were given. So I think it's very difficult to predict. And I'm sorry to be a bit wishy-washy about it, but the fact is we're in completely uncharted territory, and we don't know. I mean, there may be templates being drafted as we speak for judges to give brief, bomb-proof reasons. The Judicial College might be hard at work sorting that sort of thing out. But it's not something that, as a sitting judge, I would have welcomed, and I would wanted to take my time over it.
Another question? Yes, that lady just in the middle over, hand shot up.
Thank you. I would like to ask a question as just an ordinary person who did jury service many, many years ago, and I have no legal experience at all. That's never been my job. So it's probably quite an ignorant question, but why is abolishing juries going to make everything happen so much quicker? Does it take a huge amount of time to organise a jury? Because I understand there will be a lot of bureaucracy and everything actually administering it, but actually in the court, does it take a lot longer when there is a jury? If it is only a judge, will there be less evidence? Will it take less months in these long trials? I don't understand where the time is saved in not having a jury. I don't know, maybe that's just an ignorant question.
Yeah, I think we probably share your scepticism about that. Can we have another question? So, gentleman there with the glasses nearest you, Jan. Yeah, okay, the guy next to him.
Thank you very much. We all agree this is a terrible idea and it must be stopped. How in practice can we do that? What's the strategy for killing this?
Yes, that's a good question. Does anyone want to comment on that? How do we actually change David Lammy's mind? How do we force the government to do a 15th U-turn? Lord Boateng, you're probably closer to some of the members of the cabinet, the government, than anyone else on the panel.
There's a problem, isn't there? Because David Lammy has already changed his mind once. David Lammy came out in his report and described juries as a success story. So I wouldn't put much confidence in changing David Lammy's mind. I think what we have to do is to persuade this government that they are not going to win the argument with the public, and that there is public opposition to this, organized public opposition, that people are making it clear if each and every person in this room themselves writes to their MP and gets someone they know to write to their MP, MPs' letter boxes or email boxes ought to be full of protests against this. And I think that's a practical thing that we can do. I also think, that we in the Lords have a job of work to do. I don't believe that there's a majority in the Lords judging this particular measure on its merits, and of course we don't yet know what the measure is going to be. We have to make it clear that we're not going to vote for it, and that we're going to vote against it, and that the Parliament Act can't apply because the government has no mandate to bring this legislation forward in the first place. It wasn't in any manifesto. And we have a constitutional right, and I would argue duty, to block it.
Yep. So there's your answer. We'll kill it in the House of Lords. Yes, of course.
There's next week. There is, I think, on the 3rd of February, the Bar Council and the Criminal Bar Association have been given a room in the Palace of Westminster to hold a drop-in session for MPs, and they're going along mob-handed, and I believe there might be some advocates going robed to add a little bit of atmosphere to the occasion and hopefully perhaps get a bit of press coverage. So there's some lobbying going on, because I suspect there will be some MPs. I know there are a number of MPs who are very much against the proposal, but there'll be a lot who don't really understand what is wrong with this, and may be persuaded by the rather simplistic analysis that has been so far given. So writing to your MPs as well, you'll just get the usual Roney-Ode response, I suspect. But the more active that we are, the more chance of persuading enough people to waver.
Yes, and the Free Speech Union has a petition, a Save Our Juries petition. We've already got more than 40,000 signatures. If you haven't signed that already, please sign that. We will shortly be creating a letter-writing tool which you can use to express your misgivings about this policy to your MP, even to peers we've done in the past. So there are lots of campaigning tools we can use to try and defeat this, and I'm reasonably optimistic that we will be able to defeat it. I'm going to exercise my privilege as the chair to ask the last question myself, and I want to ask it of Adam. One of the many reasons I think this is a free speech issue is we did some analysis and discovered that if you're charged with a speech offence, you're more likely to be acquitted by a jury than by a judge or a magistrate, and to a much greater extent than the usual average, whereby you are more likely to be acquitted willy-nilly by a jury than you are by a judge or a magistrate. You're even more likely to be acquitted if charged with a speech offence. That's one of many reasons. But the reason I wanted to ask Adam about this is because, for those of you that don't know, Adam was the barrister who defended Jamie Michael, the ex-Royal Marine, whose case was taken up by the Free Speech Union when he was charged with stirring up racial hatred for a 15-minute video he posted on Facebook in the wake of the Southport attacks, in which he urged his followers to protest, and he did stress peacefully about the current levels of illegal immigration. And he was charged with stirring up racial hatred. There was a trial in Merthyr Tydfil. And Adam, what happened in that trial, and why do you think the jury, in the end, decided to acquit him?
Well, I can't read the jury's mind, of course, but we were fortunate to have a very fair, straight-down-the-line judge who didn't try to lean on the jury one way or the other. I mean, the reason we won that trial is because the evidence didn't come close to meeting the threshold. But that's not to say we couldn't have lost it in other circumstances. I've defended other speech cases, Section 127 and the like, in the Magistrates' Court, where I would say exactly the same thing. It doesn't come close to the threshold. The magistrates have, or district judge or lay magistrates have smiled at me sweetly for the duration of the trial and said, we preferred the evidence of this person to that person. Thanks very much, you're guilty. I'm afraid your excellent research is borne out by my, albeit anecdotal, experience.
And just remind us, Adam, how long did it take the jury in Jamie Michael's case to unanimously acquit him?
17 minutes. It was...
That's why we need juries. Well, on that optimistic note, I would like to thank our excellent panel, Lord Boateng, Kate O'Reilly, Christopher Kinch, and Adam King. So a big round of applause for our panel tonight. Thank you. Thanks for coming.